A courtroom in the smallest county in Ohio goes quiet on a Tuesday morning in July, and that silence is the story now. A judge signs an order, and just like that, the people who spent 2 weeks telling the public exactly what they found inside a house on Omer Street are no longer allowed to say another word about it. Not the attorney general, not the sheriff, not the prosecutor. The case that shocked a state, that pulled 16 children out of a 12 by 12 room, has just been placed under a gag order. And the timing of it raises a question worth sitting with for the next half hour. What is it exactly that someone doesn't want the public to hear next? This is the story of the Siders family of Hamden, Ohio. It's a story that started with a routine search warrant for something that had nothing to do with child welfare, and somehow became one of the most disturbing child endangerment cases in recent American memory. But this isn't just a recap. Since the world first learned about what happened in that house, 2 very different portraits of this family have been forming in public, almost in real time. One portrait comes from state officials, describing conditions they say they've never seen in decades of casework. The other comes from the family's own relatives and defense attorneys, painting a story of poverty, isolation, and a woman they say was manipulated long before she was ever a suspect. Both versions have been playing out in press conferences, court filings, and interviews for 2 weeks. And now, a judge has ordered almost everyone involved to stop talking about either one. Before we go further, if you're new to this channel, hit that subscribe button and turn on notifications, because we cover the developments in cases like this one as they happen, not months later. And if you've been with us since the first update on this case, welcome back. This one moves fast, so let's get into it. To understand why a gag order matters here, you have to understand how much was said publicly before it existed. On June 30th, deputies with the Vinton County Sheriff's Office and the Ohio Bureau of Criminal Investigation executed a search warrant at a home on Omer Street in the village of Hamden. Investigators have said the warrant had nothing to do with children. It was tied to a separate, ongoing investigation into allegations of domestic abuse and child neglect that authorities say had already been underway for roughly a month to 6 weeks. Nobody executing that warrant expected to find what they found. Inside, they say they discovered 16 children, ranging in age from roughly a year and a half to 18 years old, largely confined to a single room measuring about 12 feet by 12 feet. For scale, that's roughly the footprint of a small home office, or a single parking space and a half. Divided 16 ways, that works out to about 9 square feet of space per child, smaller than a twin mattress, before anyone even lies down. Officials say the room and much of the home around it contained human waste. Ohio Attorney General Andy Wilson told reporters the children looked like they'd essentially been forgotten by the outside world, describing the scene in blunt, emotional terms. He said that if investigators had waited even another day, there was a real possibility they'd have been responding to a death, or multiple deaths, instead of a rescue. 7 of the 16 children needed hospital care. 2 were flown by medical helicopter to trauma centers, and at least 1 was listed in critical condition. According to investigators, several of the children were largely unable to communicate. One of them, an 18-year-old, legally an adult, reportedly could not write her own name. None of the 16 had been enrolled in school, and notably, nobody called this in. No 911 call, no missing persons report, no neighbor flagging a welfare check. These children were found only because law enforcement happened to be there for something else entirely. 4 adults were arrested in the days that followed. Gary Siders Jr. and Elizabeth Siders, identified by authorities as the children's parents, and Gary Siders Sr. and Christina Siders, identified as the paternal grandparents. All 4 were charged with 16 counts each of second-degree felony child endangerment, 1 count for every child in that home. Under Ohio law, each of those counts carries a potential sentence of 2 to 12 years. All 4 were arraigned within a day of the search, each entering a plea of not guilty, and each held on a $300,000 bond. It's important to say clearly, these are charges, not convictions. Under the law, all 4 remain presumed innocent until and unless a court finds otherwise. Prosecutor William Archer has said publicly this is not being investigated as a trafficking case. Almost immediately, questions started forming that go beyond the 4 walls of that house. How does a family with 16 children go completely undetected for years in a county with fewer than 15,000 residents, in a village small enough that most people know each other by name? Neighbors in Hamden told local reporters they had no idea children were living there at all. One resident said in nearly 2 decades of walking that street, she never once saw a child outside the home. Another recalled glimpsing some of the children briefly at a yard sale, noticing they looked unwashed, but assuming they'd simply been playing outdoors. She's since said publicly that the thought has kept her up at night. Nobody interviewed so far has described hearing crying or noise or any of the ordinary sounds you'd expect from a house holding 16 kids. Investigators have said the family moved through multiple counties in southern Ohio over the years, including stretches in Gallia County and possibly Wisconsin at one point, a pattern the Attorney General characterized as the family being unusually effective at staying off the radar of any agency that might have intervened sooner. There's also reporting that a children's services agency in a neighboring county once made contact with the family in the past, after which they relocated, a sequence some investigators believe may not have been coincidental. If that's accurate, whatever was happening inside that home didn't happen overnight. It appears to have built gradually, over years, running parallel to a pattern of moves that consistently placed the family just outside the reach of whichever agency had most recently taken an interest. Now here's where the two competing narratives really start to take shape, because how you explain that pattern depends entirely on who you're listening to. The state's version, laid out by Wilson, Archer, and Vinton County Sheriff Ryan Kane in the days after the arrests, was blunt and unsparing. Kane said conditions in that house were worse than how his own department keeps livestock. Wilson used language like pure evil to describe what investigators found and said the children looked almost feral, cut off from the basic markers of a normal childhood. Not just uneducated, but seemingly unaware of how to interact with the world outside that room. It was, by his account, one of the more disturbing scenes he'd encountered in a long career in law enforcement and public service. That kind of language landed hard in headlines across the country. It also, as we'll get to, became the exact language that would eventually be used to argue for silencing the case altogether. The counter-narrative started emerging almost as fast, and it came from inside the family itself. A relative named Ronnie Fletcher, who is married to one of Gary Sr. and Christina's other daughters, gave interviews describing a family that didn't always look like this. He said the Siders' grandparents raised 4 other children who, in his words, grew into successful, functioning adults. He described the family home, at least at one point, as clean and ordinary, what he called a normal American household. Photos have circulated from a few years back, showing the grandparents looking composed and well cared for, a sharp contrast to the picture painted by investigators after the arrests. Fletcher has said the extended family was horrified by what came out, insisting that, had they known the conditions inside that home, they would have stepped in to help. He's described the relationship as distant, which raises its own uncomfortable question. How distant does a family have to be for something like this to go unnoticed for years? Fletcher's account also focused heavily on Elizabeth Siders, the mother of all 16 children, painting her less as an architect of what happened and more as someone who was absorbed into it. According to relatives, Elizabeth came from a difficult home life as a teenager and, in their telling, essentially found her way into the Siders household as an escape from something worse. She married Gary Siders Jr. in March of 2008 in Mason County, West Virginia, just across the state line from where the family was living in Ohio. At the time, West Virginia law allowed minors to marry with parental and judicial consent. Elizabeth was 15. Gary Jr. was 18. Marriage records indicate she had completed the 8th grade and he'd completed the 9th. Their first child arrived within months of the wedding, meaning Elizabeth was already pregnant at 15 when she became Gary Jr.'s wife. From that point forward, according to state records reviewed by multiple outlets, children arrived at a steady pace, roughly 1 a year for the better part of the next 18 years, including 2 sets of twins among the 16 children who survived. One of those sets didn't survive. In November of 2022, Elizabeth gave birth to twin girls, Bailey Lee and Faith Lee Siders, born extremely premature at an estimated 24 weeks, and diagnosed with a rare condition where twins are joined at the chest. Both girls died the same day at a hospital in Columbus, and their deaths were ruled to be from natural causes. Officials have said that loss isn't currently tied to the endangerment charges, but they've acknowledged it's part of the broader picture investigators are still piecing together. Counting those two, Elizabeth is believed to have given birth 18 times since she was a teenager, meaning that from age 15 to 33, she was pregnant or caring for a newborn for nearly the entire span, with no public record of formal education past the 8th grade, no record of employment outside the home, and no indication she ever lived independently of the Siders family. Elizabeth's attorney, Tommy Stolle, has been careful in how he frames her. Asked directly whether he considers his own client a victim in this case, he didn't give a clean yes. He said her behavior since the arrest hasn't matched what people typically expect from a victim, but he stopped short of ruling it out, saying the picture is still developing. It's an unusually candid admission from a defense attorney, and it tells you that even the people closest to this case haven't settled on a single tidy explanation for Elizabeth's role in it. That tension, victim or participant, architect or bystander, became the subject of a formal push in court. Stolle has filed a motion asking the court to lower Elizabeth's $300,000 bond, arguing she's 33 years old, has no prior criminal record, has never missed a court date in her life because she's never had one, and has cooperated with investigators since her arrest. He's pointed out that with the children already removed from the home and placed in state custody, whatever risk the bond was meant to prevent no longer exists in the way it did on day one. He's also noted, without much elaboration, that Elizabeth simply doesn't have the financial means to post any cash bond at all, a detail that ties directly back to the extreme poverty prosecutors say defined this household from the beginning. According to Stolle, Elizabeth's central concern since her arrest hasn't been her own release. It's been getting information about her children and understanding when, or whether, she might see them again. Not every voice from inside the extended family has landed the same way. One of Elizabeth's own brothers posted publicly attempting to explain what happened, leaning on the idea that limited understanding, rather than intent to harm, was behind the conditions investigators described. He pushed back on some of the more severe language used by officials, argued the family did what they could within their limitations, and placed most of the responsibility on Gary Sr. as the head of the household that the rest of the family simply followed. That statement drew significant backlash online. Legally, it doesn't change anything about the charges, but in a case already saturated with public attention, that kind of commentary shapes how people understand this family, whether it's meant to or not. And then there's Gary Siders Sr., the 73-year-old grandfather, whose situation has taken its own turn entirely separate from the question of guilt or innocence. Days after his arraignment, while being transported to what was supposed to be a preliminary hearing, Gary Sr. collapsed. He was taken to a hospital in Athens, where doctors identified what's been described only as a serious underlying medical condition, one requiring specialized care at a facility outside the county. His attorney has declined to even name the hospital he was eventually transferred to, citing medical privacy. What's known publicly is the legal mechanism that followed. Because he hadn't been convicted of anything, the cost of his medical care legally fell to Vinton County, not the state. And Vinton County, the least populated county in Ohio, a place where the grand jury only convenes every other month because the caseload doesn't justify more, couldn't absorb that cost without serious strain. Prosecutor Archer has said plainly that this wasn't about trusting Gary Sr. personally. It was about the arithmetic of who pays for an elderly man's medical treatment while he sits in a county jail. The judge ultimately converted his cash bond into a recognizance bond, meaning no money changed hands. But if he's released from the hospital, he'll be required to wear a GPS monitor. Just days after that hospitalization, his attorney Dorian Baum filed a motion requesting a full competency evaluation, along with notice that the defense is considering a plea of not guilty by reason of insanity. These are two separate legal questions people often blur together. Competency asks whether, right now, Gary Sr. understands the charges against him, understands the roles of the people in the courtroom, and can meaningfully assist in his own defense. If the answer is no, the case effectively freezes until, or unless, he can be restored to that understanding through treatment. Insanity is a different, narrower question entirely, asking only whether at the specific moment of the alleged offense, he understood that what he was doing was wrong. It's a legal standard, not a colloquial one, and it's rarely used successfully. Baum has described a man struggling with basic orientation to the legal process, unable to clearly explain the roles of the people around him, alongside documented physical decline, mobility problems, hearing difficulty, and what may soon require a wheelchair on a permanent basis. He's been careful to say he isn't a doctor and isn't offering a diagnosis, only relaying what he's personally observed. Notably, none of the other three defendants have raised similar questions about their own fitness to stand trial. A judge has ordered both a competency and a mental health evaluation to proceed, and the results are still pending. While that question about the grandfather works its way through the system, a separate and, for many following this case, more unsettling detail surfaced about his son. Court records obtained by regional reporters show that Gary Siders Jr. is facing a completely separate criminal complaint. 4 counts of public indecency tied to incidents dated across 4 days in late May of this year. What makes the timing notable is this. The warrant for his arrest on those charges is dated June 30th. The exact same day investigators searched the Omer Street home and discovered the 16 children. Officials have not confirmed publicly whether that separate case was connected to, or overlapped with, the domestic abuse and neglect investigation that ultimately led deputies to the house. When pressed by reporters on whether the 2 cases were linked, the Attorney General's office and the county prosecutor's office had, at the time, not responded, and the sheriff said only that he wasn't able to comment. It's a detail that raises more questions than it answers, and it remains one of the more important threads still unresolved. To be clear, these public indecency counts are separate allegations, currently unproven, and distinct from the child endangerment charges facing all 4 defendants. As the state continued gathering evidence, the response wasn't limited to the courtroom. On July 13th, Ohio's controlling board approved roughly $1 million in emergency funding to support the 16 children now in state custody. Officials with the state's Department of Children and Youth said the regional agency responsible for this part of southern Ohio saw its caseload effectively double overnight the moment these children came into care. A department official told the board that therapeutic foster care alone can run between $150 and $250 a day per child, a cost that, left unaddressed, could have bankrupted a county this small on its own. Officials cautioned that this funding is very likely just a starting point, with additional needs expected to surface as evaluations continue and the true scope of what these children require becomes clearer. That scope is part of why this case has drawn comparisons to one of the most infamous child abuse cases in modern American history, the Turpin family of Riverside County, California. In 2018, 13 Turpin children were discovered shackled and severely malnourished inside their family home, some so underweight that a 14-year-old weighed roughly the same as an average 3-year-old. David and Louise Turpin are now serving life sentences after pleading guilty to charges including torture and false imprisonment. Thomas Salisbury, the retired detective who led the original response to that case, has since weighed in publicly on what's unfolding in Ohio. And by his own account, the parallels brought back a flood of memories. The wide range of ages among the children, the total absence of school or medical records, the physical toll visible on arrival. But he's also flagged what might be the most important difference between the 2 cases. In the Turpin household, older siblings had managed to build something resembling an informal support system among themselves, passing down basic lessons, sharing coping strategies, giving each other a foundation that helped many of them eventually read, communicate, and rebuild a version of ordinary life with professional support. In Ohio, investigators have said several of the children can't speak at all, and the oldest, an adult by age, still can't write her own name. If accurate, that suggests a level of isolation that may run even deeper than what investigators found in California. Without even the fragile internal structure the Turpin children managed to create for one another. That comparison matters for another reason too. Because in the Turpin case, prosecutors didn't stop at child endangerment. Once detailed medical documentation supported it, they pursued torture and false imprisonment charges. the kind that carry the possibility of a life sentence. Right now, each of the 4 Siders defendants faces 16 counts of second-degree felony child endangerment. Legal observers following this case have noted that endangerment charges are often where prosecutions like this begin, not necessarily where they end. Endangerment doesn't require proving intent to cause specific harm, only that a caregiver's actions, or failure to act, created a substantial risk to a child's health or safety. Torture and false imprisonment require a much higher bar, evidence of a sustained, deliberate pattern, typically supported by extensive medical documentation that can take months to compile, especially across 16 separate medical histories scattered across multiple hospitals. Whether prosecutors in Vinton County ultimately pursue more serious charges may depend entirely on what that documentation shows once it's fully assembled. Investigators have said publicly that additional charges remain a possibility. Given the size and complexity of what's involved, Vinton County's prosecutor's office brought in outside help almost immediately. 2 special prosecutors, one an assistant attorney general with experience in child abuse cases, and another borrowed from a neighboring county's office, both provided at no cost to local taxpayers. Officials have stressed this isn't the result of any conflict of interest. It's simply that a rural county this small doesn't have the staffing to manage a case of this scale on its own, and the state has noted that nearly half of Ohio's counties have requested similar assistance from the same special prosecution unit within the past year. The case will still move forward on its own eventual timeline, waiting on a grand jury that, in a county this size, only convenes about every other month. Which brings us back to where we started: the silence. On July 14th, a Vinton County judge signed a gag order tied to the case against Gary Siders Jr., barring the Attorney General's office, the county prosecutor, the sheriff, the clerk of courts, and Gary Jr.'s own defense attorney from making further public statements about it. The request came directly from Gary Jr.'s attorney, who pointed specifically to some of the most quoted language from the early days of this case: the comparison of the children's living conditions to how the sheriff's department treats its own livestock. The description of the children as looking almost feral, even the repeated public references to the 12-by-12 room. His argument was straightforward. Language like that, repeated across dozens of news segments and headlines, risks tainting the pool of potential jurors before either side has presented a single piece of evidence in court. He's argued that officials have effectively been trying this case in the court of public opinion, using extreme and emotionally loaded language without giving the defense any real opportunity to respond to the underlying evidence. The judge agreed, finding that the volume and tone of public commentary so far created what she described as a reasonable likelihood of prejudicial pretrial publicity, enough to potentially compromise either side's right to a fair trial. That order technically applies only to the case against Gary Jr., but because all 4 defendants are facing functionally identical charges arising from the same set of facts, it's already having a chilling effect across the board. And it didn't stop there. Attorneys for Christina Siders have now filed a second request, asking the court to bar all parties from discussing evidence, discovery materials, or the credibility of witnesses and alleged victims in her case as well. If granted, that order would go even further than the first, closing off nearly every remaining public channel through which new information about this case has been reaching the public over the past 2 weeks. It's worth sitting with what that actually means going forward. For 2 weeks, nearly everything the public has learned about this case, the room, the hospitalizations, the marriage records, the competency questions, even the newly surfaced public indecency charge, came from officials speaking on the record, court filings becoming public, and family members choosing to talk to reporters. A gag order doesn't make any of that untrue. It doesn't undo what's already been reported, but it does mean that from this point forward, the flow of new information is likely to slow to a crawl, at least from official channels, right at the moment when the most serious questions about additional charges, about what medical evidence ultimately shows, about whether Gary Sr. will ever be found competent to stand trial at all, remain completely unanswered. Defense attorneys involved in this case have made clear they see the gag order as a necessary correction, not an attempt to hide anything. Dorian Baum, representing Gary Sr., raised concerns earlier this month about the sheer volume of media attention in a county this small, arguing it makes it genuinely difficult to guarantee an impartial jury when the state has already characterized the case in such stark terms before any evidence has been formally presented. Whether you find that argument convincing likely depends on where you land in this broader tension between the public's interest in knowing what happened to 16 children and a defendant's constitutional right to a trial that isn't shaped by 2 weeks of viral headlines before it even begins. What isn't in dispute, at least not yet, is what happens next for the 16 children at the center of all of it. They remain in the custody of Ohio's Department of Children and Youth, spread across a system now attempting to coordinate medical care, therapeutic support, and, eventually, some path toward stability for children who, according to investigators, had none of the basic building blocks most people take for granted. No school enrollment, limited or absent verbal communication, and in the case of the oldest, no ability to even write her own name. Detective Salisbury, drawing on what he learned in the years after the Turpin case, has been direct about what he thinks needs to happen, keeping these children together where possible, rather than scattering them individually across a foster system where oversight can quietly slip through the cracks, and surrounding them immediately with specialized professionals rather than waiting for problems to surface later. He's noted that the Turpin children are, by most accounts, doing well today, years removed from what happened to them, but that outcome took sustained, coordinated care, not just a single rescue. Whether Ohio provides that same level of long-term investment for these 16 children may end up mattering far more than anything that happens inside a courtroom. And then there's the question nobody in an official capacity has fully addressed. The 18-year-old among these 16 children is, legally, an adult. She ages out of the systems designed to protect minors, potentially while still unable to read, write her own name, or navigate an unfamiliar world she was almost entirely shielded from. What services exist for someone in her exact position isn't clear yet, and it may be one of the most urgent, least discussed parts of this entire case. So where does this leave things as of today? 4 adults, presumed innocent, facing charges that could still expand as medical evidence comes in. A grandfather whose competency to even stand trial remains an open medical and legal question. A mother whose own attorney can't say definitively whether she was a perpetrator or, in some sense, a victim of the same system that failed these children for years. A father facing a second, unrelated set of charges whose connection to the original discovery still hasn't been publicly explained. And now, a courtroom that's been ordered into silence, right as the investigation moves into whatever comes next. The state's version of this story called it almost feral, pure evil, worse than how livestock are kept. The family's version calls it poverty, isolation, and a woman who was pulled into something long before she had the tools to recognize what it had become. Maybe both are partly true. Maybe neither fully explains it. Cases like this rarely resolve into a single clean narrative, no matter how badly the people watching from the outside want one. What's certain is that 16 children are now trying to build something resembling a normal life, starting from almost nothing, and the adults who were supposed to protect them are the ones a court now has to decide whether the public gets to hear from at all. There's also a broader question sitting underneath this entire case, one that has nothing to do with any individual defendant. Systems exist, at least on paper, to catch exactly this kind of situation before it reaches 16 children in 4 years. Schools notice absences, neighbors notice patterns, agencies follow up on reports. In this case, by nearly every account gathered so far, those systems either weren't triggered or were triggered and outrun by a family that kept moving before anyone could act. That gap, between the systems that are supposed to exist and what actually happened on the ground for years in rural Ohio, is likely to outlast the gag order, the competency evaluation, and even the eventual trial itself. If investigators or anyone connected to this case has information relevant to the ongoing investigation, Ohio's Bureau of Criminal Investigation has asked that tips be directed to their official hotline. We'll continue following this case as new developments become public, gag order or not, because these aren't just headlines. They're 16 real children whose next chapter is still being written. If this update helped you understand where this case actually stands right now, hit that like button, leave your thoughts in the comments, and subscribe so you don't miss what comes next.